My court's going to call a group of cases, All People versus Matthew Kafori, 25T53, 24T75, 24T392, 24T368, 26CR10, 25M153, 25M154, 26CR5, 25T108, 25T233, 24T275, All People versus Matthew Kafori. Counsel?
Catherine Decker for the people.
And Your Honor, Daniel Gagarin from the Public Defender's Office on behalf of Mr. Kafori on all cases today. However, Mr. Kafori, as I informed the court staff, Mr. Kafori did indicate that he wishes to waive counsel. And so
Also had at some point, and it's hard to keep track of with all these cases, ADC appointed on some of them. Do you know, Jetta? I'm asking you a tough question. All right. We did have ADC on some cases.
It looks like at one point it was Jeanne Villalobos. They're actually on the docket with her name, the ones that have them. Do you want to see the docket?
Yes, thank you. Actually, I've got mine. All right, Mr. Gagarin, that's your understanding is Mr. Kafori wishes to waive his right to an attorney today.
that is my understanding, Your Honor. I have been appointed to the 2 felony cases. I thought Ms. Lyle had been appointed to all the misdemeanor cases. But Mr. Kafori informs me that he wishes to waive counsel on all of his cases. And so I discussed with him the advisement that the court would go through for that.
All right. I'm going to start, Mr. Kafori, and just advise you, I know we've gone over this for a number of these cases. 2 of these are at least your first appearance on these cases. You do have the right to remain silent and do not need to make any statement. Any statement you do make can be used against you in court. You do have the right to be represented by an attorney throughout your case. If you cannot afford to hire an attorney or you remain in custody, you have the right to ask the court to appoint one for you. Any plea you enter must be voluntary and not the result of undue influence or coercion. You have the right to have bail set in your cases. You have the right to have a jury trial. If in 2 of these cases, I believe you do have the right to have what's called a preliminary hearing. A preliminary hearing must be set within 35 days of the filing of charges or after you demand it, if you wish to demand a preliminary hearing. The purpose of a preliminary hearing is to determine if there is probable cause to believe that the offense charged has been committed and that you are the person who committed it. From this point until final action in your cases, you are prohibited from harassing, molesting, intimidating, retaliating against, or tampering with any witness to or victim of the acts charged. If your cases involve domestic violence, you're prohibited from having contact if already ordered. I will let you know that there have been 2 additional cases that I don't know if you have been advised on. The first of them is 26CR5. 26CR5, the district attorney filed a felony complaint and information indicating 3 charges. Count number 1, vehicular eluding, a class 5 felony that on or about December 29th, 2025, Matthew Mark Kafori, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempted to elude Jonathan Roy and or Austin Minicho Sikora, a peace officer also operating a motor vehicle, when the defendant knew or reasonably should have known that he was being pursued by the peace officer and operated his vehicle in a reckless manner. That carries a possible penalty of between 1 and 3 years in the Department of Corrections. Count number 2, driving under restraint. On or about December 29th, 2025, Matthew Mark Kafori unlawfully drove a motor vehicle upon a highway with knowledge that the defendant's license or driving privilege was under restraint in violation of sections 42.2, 138.1A, carries a possible penalty of up to $100. Count number 3, reckless driving. On or about December 29th, 2025, Matthew Mark Kafori unlawfully drove a motor vehicle or a low-power scooter in such a manner as to indicate a wanton or willful disregard for the safety of persons or property in violation of section 42.4, 1401 CRS that carries a possible penalties of up to $300, up to 90 days in jail, or both. In 26 CR 10, the district attorney filed a felony complaint and information in that matter, alleging 3 charges. Those three charges read the same, but they indicate that they were on January 14th. Count 1, vehicular eluding. On or about January 14th, 2026, Matthew Mark Kafori, while operating a motor vehicle, unlawfully, feloniously, and knowingly eluded or attempted to elude Deputy Brett McWilliams, a peace officer also operating a motor vehicle, when the defendant knew or reasonably should have known he was being pursued by the peace officer and operated his vehicle in a reckless manner in violation of section 18.9116.5 CRS. And then, like the other charges I read to you, it also includes a count of reckless driving and a count of driving under restraint, both alleging that it occurred on or about January 14th of 2026. Do you understand the charges in those two cases as I've read them to you?
No, I don't.
Welcome
Didn't think
back,
that he was just a bad
everyone.
counsel.
Today's case is a perfect example of how a bad situation can become dramatically worse when someone decides they're smarter than the legal system. The man at the center of this hearing, Matthew Kafori, is already serving a 120-day jail sentence, but somehow that's only the beginning of his problems. According to the allegations, while trying to avoid the consequences of one case, he allegedly picked up not one but two separate felony vehicular eluding charges, each carrying potentially serious consequences. Now, if you've watched sovereign citizen cases before, you probably know the pattern. We often see arguments about jurisdiction, challenges to the court's authority, references to constitutional violations, and attempts to bypass the actual criminal allegations by focusing on procedural claims. But here's what makes this hearing particularly interesting. The judge is dealing with a defendant who wants to represent himself while simultaneously claiming that the court has no authority over him. As this hearing unfolds, pay close attention to how the judge handles those arguments. Notice the difference between legal issues that can actually affect a case and arguments that may sound important but don't change the court's ability to move forward. Also, watch how the discussion shifts from the underlying charges to questions about bond, jurisdiction, and self-representation. By the end of this hearing, you'll see a fascinating clash between courtroom procedure and a defendant determined to challenge nearly every aspect of the process. And trust me, some of the exchanges coming up are ones you won't want to miss.
Your Honor, today I'm appearing sui juris and propria
Well,
persona.
I'm going to tell you really quick, Mr. Kafori, I just read those charges out loud to you. Do you
Okay.
understand those charges? If you don't understand those charges, I'm not going to allow you to go forward without an attorney. I want you to be represented by someone who understands the charges. Do you understand the charges as I've read them?
I understand the charges as you have read them. Okay.
All right. Do you understand the rights that I read you in regards to all of these cases, including your right to silence, your right to counsel, trial, bail?
Yes, I do understand those rights, Your Honor.
All right.
I do have some statements
Now-
that I would like to make in regard to the advisement that you just gave me.
Now, let's talk a little bit more about your right to an attorney. Is it correct that you wish to go forward without an attorney in these cases?
I would like to reserve all my rights, and I'm waiving my right for counsel.
For today's purposes?
Yes, sir.
Okay. Now, some of your cases do have we believe that there was alternate defense counsel appointed on them because of your failure to appear some time ago. I don't know if they are still in those cases, but in regards to those cases, do you understand that Ms. Villalobos would represent you in those cases?
I would like to waive my right to counsel in those cases as well.
Understanding that you do have the right to remain silent, you do have the right to have an attorney. Well, let me just ask a little bit more regarding your right to counsel. You state you do understand your right to have an attorney and you wish to waive it for today. Is that correct?
That is correct.
When you waive that right, well, is this your knowing and voluntary decision?
Yes.
Are you under the influence of anything?
No.
Are you thinking clearly?
Yes.
Has anybody made any threats or promises to get you to do this today?
No.
Do you understand that I will appoint counsel if you want an attorney to represent you?
Yes.
Do you understand the charges that I indicated on those two cases, and that the other cases involve charges that include possible jail time in the county jail? Do you understand those possible penalties, including up to 3 years in the Department of Corrections in both of the new felony filings? Do you understand those possible penalties?
Yes.
Do you have any legal training?
I do not. No
How
formal
far have you
training.
gone? How far have you gone in school?
I have a high school diploma.
Do you want to speak to the public defender any further before you make this decision here today?
No, I don't.
Do you understand criminal law is a complicated area, and that an attorney trained in this field could be of great help in preparing and representing your defense?
Yes.
Do you understand that that while you have the right to represent yourself, but that by doing so, you take a great risk of not properly presenting your case or your arguments?
Yes.
For this hearing, at least, knowing all of this, is it still your desire to represent yourself?
Yes.
All right. I think a couple of things we need to do. I've advised the defendant on the charges, Ms. Decker, and so I think on those cases, I need to ask him how he wishes to go forward, whether he wishes to have a preliminary hearing on those matters and have those set for it. I do think we need to address bond in at least some of the cases, and he does have the right to have a 48-hour bond hearing in those charges, or he does have the right to have a bond hearing in regards to those new cases at least, and some of the traffic offenses. I think I'm obligated by law to make some changes. But do you agree that that's, Ms. Decker, that how we at least minimally need to proceed today?
Yes, Your Honor.
All right. Mr. Kafori, you stated that you wanted to speak to me. Now, understanding your right to remain silent and anything could be used against you, what is it you wish to talk about here today?
Okay, Your Honor, for the record, I'm appearing sui juris and propria persona under special appearance only to challenge the jurisdiction of this court. I reserve all my rights and waive my right to counsel. I have not seen a writ of habeas corpus for my production, and I do not consent to this video appearance under Rule 43. The 13 warrants have never been served to me. I believe I am currently being held in a legal black hole 31 days past the 48-hour mandate that you just mentioned of CRS 16-4-102. Today, I am challenging jurisdiction. I would like the dismissal of all charges, the return of my vehicle that was illegally seized, and these charges to be dismissed with prejudice There's a multitude of due process violations that have happened. I'm 31 days currently past my Rule 5 advisement and the 48-hour mandate for bond setting, which is quite some time. My vehicle was illegally searched and seized for me on April 1st out of Aurora off of private property.